that's but if that's what it looks like to those who are viewing from the screen, we got plenty of light.
Yeah. I want to make sure that you guys can see. Yeah. Put in a GAWL.
How are you? Great. Hey, I'm Daryl. Thank you.
Thank you.
Say the same thing last summer. It was traumatic. One of the worst experiences in my life. Now, I'm far removed from it now.
Let's say one of the worst experiences of your life.
I can feel all of that. So it's been so long ago now. But yeah, we don't. Not at all. I'm a witness. It was not.
It's maybe controversial, but I think a denser donut. I still love like the crispy every once in a while, but I don't want to long.
You're speaking to the best place.
I completely
Everything else I
agree.
think is great.
Completely agree.
You go to Dunstable.
Absolutely.
But that's like a chocolate cake donut. It's those chocolate icing on top.
Yes.
It's just decadent. You're just eating it. This is mine. This is my wife and Trip.
When I see them now.
Is a cup.
When I was.
Good for you.
Right.
Okay.
Mark is here. He's the IT guy.
Yeah.
I can go grab
Can you
him.
grab him?
Yeah.
Real quick, and then we'll get started.
Oh, no
All right,
worries.
Thank you so much.
Anybody up on the stage? So not-
That's where you don't. Yeah, it should not have. Well, it's also.
You feel a little
It's
dark.
not good. The ceiling's a little low. Okay. It's gotta be a flat. There you go. That's funny.
Yeah, there we go.
Yeah, oh yeah, that's better.
Perfect. Thank you so much. You ready, Lauren?
Good, we're already recording, so.
Great. Thanks, ready?
Yeah.
Okay, we're gonna do a quick welcome. Then we'll
Okay,
go to the
great.
panel.
Are these on? There.
Okay. Good morning, everybody, and welcome to GAWL's State of the Law and AI CLE. Thank you all so much for joining us. And special thanks to our live stream sponsor and our special guests here. We had Attorney Daryl Sutton as well as Justice Pinson with us for the first panel. We are very excited to get started today. The event will be in two panels. First, a perspective from the bench and the bar, then the second panel, a quick break, and then the second panel will contain attorney experts who are utilizing AI in very interesting ways in our profession. So we're excited to hear from everybody. Our virtual attendees, if you have any questions or concerns or Q&A, we will have a Q&A portion. Please go ahead and write those questions in the chat and we will get to them during the Q&A portion. This event has been approved for 2.5 CLE credits, 1 credit of ethics. For our virtual attendees, I will give a quote unquote password towards the end of the CLE, and then just need to email your bar number and the password to the president of GAWL. You should have gotten an email with that email address. If you guys have any questions or concerns in the meantime, please write it in the chat. We'll be monitoring it and I can assist accordingly. My name is Margaret Riley Schweizer, if I did not say that earlier. I am Vice President of Programs for GAWL this year, and I'm very happy to be here. Before we get started, we're going to hear a quick word from our live stream sponsor, who is generously assisting us in the streaming of this event today, Veritext, and Lauren Berry. Thank you.
Thank you. Thank you. Such a cool event. It's so hot right now. I just wanted to say, we are so happy. Veritex has been a sponsor. I want to say almost 10 years of all, so I can continue that. It's one of my favorite things that we do stream because it allows us to really be a state organization and have people from not Atlanta or just unable to make it for whatever reason to join. And if you ever need CLE credit hours, I always like to share. Veritex offers free CLEs. They're about once a month. They're online, they're webinars, very similar format to this. We gave a code at the end and you literally just enter the code. And with Georgia, we can self-submit on your behalf. So if you're interested in that, I'll put it in the chat, but for those in person, veritex.com/CLE. For those in person, reach out to me. I can give you that link if you need it, and I'll put it in the chat. Thank you. Happy Friday.
Thank you so much, Lauren. So we're going to get right into our first panel. Hey, well, good morning. I will be moderating our first panel today and just giving a very quick overview of our two esteemed panelists' bio. You both have done so much and your bios are long. So please feel free to highlight anything that I have missed when I kind of do a quick overview of both of you. We first have Justice Andrew A. Pinson, who was appointed to the Supreme Court of Georgia in 2022 by Governor Brian Kemp. He was elected in 2024 to a 6-year term. He was born in DeKalb County, Georgia, and grew up in Lithonia and Lawrenceville. In middle school, he moved to Lincolnton, and he graduated from Briarwood Academy in Warrenton. He is a double dog with a finance degree from the University of Georgia's Terry School of Business and a law degree from the University of Georgia's Lumpkin School of Law. He graduated the top of his class and while in school interned with the Office of Executive Counsel for the Governor, Jones Day, Fortson, Bentley, and Griffin in Athens. We also have Mr. Daryl Sutton of Sutton Law Group. Leveraging more than 20 years of experience as a civil litigator and leader in the profession and the community, Daryl and his firm help clients see beyond their civil legal issues to solutions. He's a specialist in general civil liability litigation, insurance coverage counsel and litigation, external general counsel services, workers' comp litigation, and so it says here, there's few legal issues Daryl has not encountered and none he cannot solve. I think is great for a bio.
Great marketing.
Yeah. Well, we're here to talk about the state of AI and the law. And I brought these two gentlemen with us in particular because Justice Pinson leads the Judicial Ad Hoc Committee examining AI from the court system's perspective, and Attorney Sutton chairs the AI Study Committee for the State Bar of Georgia. Justice Pinson, maybe we'll start with you. If you could share briefly your role in this work and where things currently stand. I know the landscape changes rapidly.
Yeah, thank you. And first of all, thank you to GAWL and thank you for having us. It's a fantastic idea to keep up on the advancements in AI, which are rapid and ever changing. I think it's a really important thing for us to keep thinking about to make sure we do things the right way. As you said, I was appointed to chair the Ad Hoc Council on Artificial Intelligence for the Judicial Council. That came about, I think, largely because then Chief Justice Boggs back in 2024, realizing that AI was going to be a very big deal, and that seems forever ago in terms of AI at this point, looked around the bank table and saw me and said, "You look young and hip. I bet you know about technology. Why don't you take a crack at sort of leading this?" And really the point of the committee, it was very much a jumping off point, not, hey, we're going to crack this nut once and for all, but we need to wrap our arms around even sort of what this technology is, what are its risks to sort of the legal profession and especially to courts, and then kind of what are its benefits for things like access to justice, the administration of justice, how we do our jobs as court. And so pulled together a representative from every class of court in Georgia, from the state bar, my friend Daryl, co-chaired by Judge Stephen Kelly from down in Brunswick, and then Judge Elizabeth Gobeil on the Court of Appeals also played a large role. And we took essentially probably 6 or 8 months, and over those 6 or 8 months, learned everything we could about AI, partnered with the National Center for State Courts to bring in experts to help educate us and help us understand kind of the landscape and what we needed to be thinking about in terms of the risks and benefits of AI. And then at the end of the day, issued a report, which I'm happy to get into in a bit, that talks about sort of what the landscape is, what we need to be thinking about, and gives some sort of potential sort of uses of AI and also kind of some things to think about and worry about for courts going forward.
Thank you, Justice. Mr. Sutton?
Yes, so the bars committee has a similar genesis. It too was created at the behest or then Chief Justice Boggs, who asked then bar president Ivy Cadle to create a committee to do the same thing that the courts ad hoc committee was doing, but from the bar side of things. Our committee was appointed with two tasks, or was given two tasks. Number one, assess the Georgia rules of professional conduct to ensure that they are sufficient to address the increasing use of AI among lawyers. And then two, develop whatever we felt was necessary to help Georgia lawyers implement responsibly artificial intelligence within their practices. What we discovered, so we went into our work believing that we were to tackle those in that order and that we would have to get through number one in order to get through number two. What we discovered is that I think somewhat encouraging to me is that of the 200 some odd Georgia rules of professional conduct, when you include subparts, we found only 3 that needed any modification to address AI, which to me means that the rules are written in a way that they, despite time and advancements in any field, are well suited to fit and to provide guidance to Georgia lawyers as they practice with any particular historical point in time. Excuse me. And so that work was done somewhat quickly, and then it was completed. 2 of the rules that we found that needed some modification were already in the process of being modified, consistent with what we thought needed to be done. And then the 3rd rule modification, we are currently working with the bar's disciplinary process, or rulemaking process, to see that to completion. So what our work really ended up focusing on was the second of our tasks, which was the development of tools and other items to help Georgia lawyers responsibly implement artificial intelligence in their practice. And so we, after several months of work across 2 bar years, have developed an artificial intelligence toolkit, our AI toolkit, which is housed on the bar's website and run by the bar's law practice management program, which is a one-stop shop for any Georgia lawyer, and it doesn't have to be a Georgia lawyer, for any lawyer who is looking to implement artificial intelligence in their practice. Everything from basic definitions, a glossary of terms that you would need to know, to links to other resources from other state bars and other law-related entities that have studied or worked on this issue, to an itemization of the risk considerations that need to be taken into account when implementing artificial intelligence in your practice, to the intersection of the rules of professional conduct and the use of AI. Now, to hopefully provide some guidance to Georgia lawyers about when vetting an AI platform to implement your practice, what do you need to be on the lookout for? What do the different platforms offer or not offer? And what are the potential risks or benefits to using one platform versus another? Not in the form of an endorsement, but more in the form of an education. Here are what the different platforms are, and here's what they do and don't do.
Yeah, that's fascinating. And I downloaded the PDF of that toolkit as well as the link to the landing page because I thought it had wonderful information for a wide variety of people with experience with AI. And I put that on the materials for the CLE, so everyone should have access to that. Out of curiosity, Mr. Sutton, what were the 3 Georgia rules of professional conduct that needed to be amended?
Yeah, I'm going to ask Curtis to correct me if I get any of this wrong. So 1.1, dealing with competency and the whether competency involves being competent with technology and different technologies. Rule 1.6, dealing with confidentiality. And then Rule 5.3, dealing with the lawyer's obligation to supervise a non-lawyer and the identification of an AI tool as a non-lawyer that the lawyer has an obligation to supervise.
Yeah, and that leads right into my next question. I had particularly focused on Rule 1.1 regarding competency, Rule 1.6 regarding confidentiality. Where do you both see, thinking through the lens of those rules as the most opportunity or the biggest areas for opportunity in the space of AI as well as risk?
Yeah, sure. And I don't want to speak from the court's perspective, but there's an
Sure.
interplay between what we do at the bar as far as rules go and what the Supreme Court does. And the bar develops the rules, but ultimately the rulemaking authority for the profession of law rests and lies with the Supreme Court. And I think the court's perspective on this is the right perspective. When we went into it, our feeling was that in order to be competent as a Georgia lawyer, you had to be competent with technology, and that included artificial intelligence. And I think that the court's perspective, which I agree with, is that that's not necessarily the case. If you use a particular form of technology within your practice, then you need to be competent with it in order to be a competent lawyer. In other words, you don't have to go into the dining room to eat, but if you go in there, you better not break the china while you're in there. And so we have sort of taken a step back and modified what we were advocating so that it's more narrowly tailored. So to encourage lawyers to use technology appropriately within their practices, but to ensure that it's only the lawyers who venture into one area of technology or another that have to be competent in its use. And artificial intelligence obviously is one of those technologies.
Yeah, I think Daryl put it well in terms of how I look at these rules and competency, and I think how the court does too. And that is, competency is about competency to practice law, right? You can practice law in a million different ways with a million different kinds of tools. And so, you know, it doesn't necessarily violate 1.1 to not know how to use a particular technology. If you just don't use the technology, that doesn't necessarily mean you're incompetent. If you do use the technology, you better use it in a way that sort of maintains your competence in the sort of underlying practice of law. And I think that goes, you know, if you want to generalize that to the rules more generally, you know, both on the bar side and then the Code of Judicial Conduct, which governs a lot of these things for judges and staff attorneys. The reason we don't have to change a lot of the rules, and we did a similar look at the Code of Judicial Conduct and realized we're not sure we really need to tweak anything, because again, it's about the practice of law. This is a tool that can help or hinder your practice of law. And so you have to continue to follow those rules as you use the tool, and it's going to butt up against some of those rules in terms of, you know, best practices. It's going to butt up against them in terms of, you know, you talked about confidentiality. Like, it's going to make you think very carefully about how you can use this tool in a way that's consistent with those rules. But at the end of the day, the bottom line is you need to do these things to follow the rules, not, there's no sort of new AI specific rule that we saw that we needed to implement.
And I think we went into it, and I don't want to speak for the committee, but from my perspective, having chaired the committee, I think we went into it believing that we needed to do that we needed to be sort of AI centric in our analysis. And I think, and so that's what we initially did. I think having taken a step back over 2 years of work, I think we've realized that that's not necessary, that what we need to understand is, or what we need to be focused on or need to encourage and promote is the responsible use of this technology, just as we would any technology. It just so happens that this is the one that everyone is focused on right now, or that is getting the most attention right now.
All that said, education is still a
Yeah,
huge component, right? Because the rules may be the rules, and they may not sort of say anything specifically about AI, just like we, you know, don't say anything specifically about, you know, which word processors you use. But we need to know how these things relate to those different rules and how to use them responsibly and within the rules. And that may not be, it's just that the rules themselves are not sort of the microphone for getting that education out there, right? We need to do that in other ways.
And I think rightfully so, the focus, this particular technology has created more concern or more issues than others have, because by its very nature, how it works, it poses more risk to a lawyer than most other technologies that lawyers have ever encountered before. And so there has, rightfully so, been some high and more intense focus on this technology and its intersection with the rules of professional conduct. The idea is to ensure that the rules continue to exist in a way that they govern whatever technology may come or whatever historical pivot point we may encounter.
Sure. So we obviously hear a lot of horror stories in front of Justice Benson in our own law firms all the time. There's been very interesting standing orders that are being generated almost daily. And I definitely want to get into the risk involved because I think that's a lot of the fear, right, around this, or ending up on Facebook with a funny story, being humiliated, right? But where are attorneys getting it right? Where are both of you seeing, whether from it's the bar perspective or in your practice, Mr. Sutton, or in front of you, Justice Pinson, where are the attorneys that you can, is it getting right? Is that you can't tell? Is that what it getting right looks like when an attorney uses AI effectively and ethically?
I never thought about it that way, but I think it's an excellent point. If you can't tell, then they're probably using it correctly, or they're not using it at all, one or the other. And some would say that that is the correct use of it, is not using it. I let me caveat my answer with I am, as I told the committee when we met yesterday, I'm an analog man living in a digital world. So I am least savvy when it comes to this technology. I've learned a ton about it, and I know a lot about it just by virtue of the role that I've had. But as far as actual utilization of it, listen, some folks we're going to have on this next panel can speak to that 100 times better than I can, if not greater. I think that those who are using it responsibly know what it does, but more importantly, know what it doesn't do. I think that those who use it responsibly understand that it is a tool of enhancement and not a tool of replacement. And I think those who use it responsibly understand that its biggest benefit right now is in any task that a lawyer encounters that can be automated, and that any task that a lawyer encounters that requires independent judgment or decision making, it is a tool to help them, but not a tool to replace what they were otherwise doing.
I would agree with that. I do think it's a good observation that right now, likely the ones who are doing it right are the ones we don't notice so much because, we do notice hallucinated cases. We do notice, I've certainly noticed in sort of reading briefs, you can kind of tell which ones have used sort of AI to just draft language and paste it into the brief, and it's not sort of done in a way that makes the brief better. It looks like it's just sort of a shortcut because you can, I think most of us know at this point, sort of, you can read passages and get, hey, this may be written by AI, whether it's because of strange use of M dashes or just the diction. There is sort of an AI-ified way of writing.
They're telltale signs for sure.
Yeah. Unlike Daryl, I am fascinated by technology and early adopter and all those sorts of things, and have used AI in my personal life for, some time for, all kinds of stuff from like, doing lawn care and all sorts of things like that. So I do think that when people are using it right in the legal profession, and I will say, I've sort of, the court, like I think any other organization, is sort of assessing these tools. And so we're just trying to get a sense of like what's out there and is there something that could be useful for us. I think that that's the right thing to do for any lawyer who's using it, right? Like you really need to understand in a way that maybe wasn't true of, again, word processors or basic Westlaw and Lexis. Like you really need to understand at some level, not exactly how it works, because I'm not sure anyone knows exactly how AI works, but
Not even those who produce the product.
right. But you need to understand like what it is doing and what it's not doing, right? When you type in a prompt and it sort of goes through this path of like, it's telling you, okay, I'm doing this kind of reasoning, I'm figuring this out, I'm figuring it out, like your answer. Like it is not like a human behind that box doing human kinds of reasoning. It is still sort of going through these processes and algorithms and things that there may or may not be sort of something behind there that is real. And so you've got to sort of be very careful about what its output is and what it can be used for. But I think there are certainly use cases for it. I mean, I know that many lawyers are using AI, and that's not an inherently bad thing. I think there's a lot of sort of efficiencies to be gained both for your clients and kind of for your own work-life balance to sort of use AI in a responsible way. It's just a matter of, again, I think Daryl put it well, like you've got to know what it's good at and what its limitations are, and not sort of push it to do things that are going to get you in trouble.
Yeah, I hear a lot. There's a couple of camps of folks out there. There's those who believe that they're going to plug an AI machine into their law practice and they're going to go sit on the beach and let AI practice law for them. And there's those who believe it's black magic. Neither of those is true. The truth is somewhere in between. I think that those who use it responsibly approach it like Ronald Reagan approached the Soviet Union at the end of the Cold War, which is trust but verify. You can trust that it's doing what it's supposed to do, but you better verify what it's done to ensure that it's correct.
Yeah. So in looking at this, I think I was talking to one of my staff attorneys the other day about how we might, like how someone would use AI in a way to sort of get, do legal research or whatever. And it's like, treat it like maybe like a smart intern, right? So like you've got to be very specific about what you want. You've got to sort of prompt them in a way that gives them all the context they need and all the information they need. Probably going to have to tell them a few different times, like, that's not quite right. That's not quite right. And then at the end, you can't really trust anything it gives you. You need to sort of go back and verify and make sure that there's sort of real cases behind it and that those cases actually support what they're saying.
Now, the difference between AI and an intern, however, is the speed at which the product is developed. So you're right. People are, well, then why would I use it? Because you are still employing these steps that you would have to use with an intern, but you're doing it in a matter of hours rather than a matter of days.
Yeah.
You both are nicer than me. I call it a stupid first year. So I like smart intern better. I'm gonna write that one down. Justice
A
Pin-
fast intern. maybe.
that fast
There
intern. Justice Pinson, let's talk about the hallucinations. So what is your opinion on how AI generated hallucinations making their way into court filings implicate an attorney's duty of candor to the tribunal under Rule 3.3?
I mean, it has never been consistent with that rule to cite made up cases to a court, right? AI has just made that a possibility in a way that I think it wouldn't be before, except to the most brazen attorneys. Right? I mean, it's just, it would never enter your mind in writing your own brief without the use of AI, where you're plugging in sites and things to just come up with a case that doesn't exist, right? From time immemorial, attorneys have sort of pushed the boundaries of like, does this case really support this proposition? But I think that's, that's different in kind from cases that simply don't exist at all. And so that's kind of I think that's the big, the single big sort of change from what we've always done. And you always have sort of a spectrum of sort of how far are you willing to push this proposition? And, a lot of that is sort of zealous advocacy, right? Like this doesn't sort of directly support the proposition, but it certainly can be read to support it or help with it. Whereas cases that don't exist don't help at all and violate the rule. So I think that's pretty straightforward in terms of the rule itself.
Are courts beginning to treat AI-related errors, if you will, differently than other errors, to your point?
Yeah, I mean, I think I'm afraid that the answer is yes, that when they hear AI, there's sort of a smackdown in a way that maybe you wouldn't get with other kinds of problems that you see before a court. It is a little bit hard to tease apart, again, the fact that you used AI for this from the fact that you are citing a made up case to a court, which is a thing that we didn't really see before, right? So the question is like, what is the proportionate response for someone who cites a made up case to a court? And I do really think it's important for courts to think about like, what's the appropriate sanction for that, and put aside the fact that it's done with AI. Now, I think maybe the use of AI there's a component of that in that you're not sort of being careful and sort of comprehensive in your checking of your work and things like that. But I think at the end of the day, we have to look at what's the thing that violates the rule. And there's no rule against using AI. And in fact, there's going to be a ton of use case for AI over the years. So I do think courts need to be careful not to just be sort of reflexively anti-AI, be anti making up cases, be anti sort of making up quotations, anti sort of AI slop in briefs, but don't be just sort of anti the technology itself, which at the end of the day, the lawyer is prompting and generating the text and deciding to put it in the brief and file it.
I'll give I hate this phrase, but I'm gonna use it anyway, a more Main Street perspective on that. My sense, and this is anecdotal and just from observation and discussions that I've had with judges, my sense is that the penalties that judges have to apply for misbehavior in their courtroom is the same for lawyers and non-lawyers. And I can tell you that from a lawyer's perspective, dealing with on a daily basis, interfacing with clients, both those that are sophisticated corporations and those that are individuals, the receipt of inquiries from a clients that you can tell are generated by AI is similar to what trial judges are facing with non-represented litigants.
Mhm.
And I think that judges have to apply the penalties for use of AI the same equally between lawyers and non-lawyers. And so I think there's probably some over penalization of lawyers for it simply because the judge can't treat a lawyer differently for using it than a non-lawyer. And I think the tolerance for it, because it is so much more rampant among non-lawyers, is less than it otherwise would be if it was just lawyers doing it. I will say that I think if you asked that question a year and a half ago or 2 years ago, the answer would be probably different. But I think now there's been so much publicity of lawyers inappropriately using the technology that I think judges have less and less tolerance for it. In other words, a situation where 2 years ago you could legitimately, as a lawyer, some legitimacy, say, "Oh, I didn't know that could happen." Now there's no excuse for it. You have to have been in a hole for the past 18 months to not, as a lawyer, to not have read story after story after story after story of lawyers misusing AI and it hallucinating or creating things that just didn't exist. And so now you have no excuse as a lawyer. If you do it, you're either doing it willfully or you are so out of touch with what is going on that it borders on willfulness.
Yeah, like the presumed mens rea has to sort of change over time from I'm using this new technology and it's great. Oh, I didn't know to make up cases to, and you just are either you're just trying to get it past the court or you just ran out of time and are being, like you said, grossly negligent.
I want to talk a little bit more about the judiciary's response to AI in the form of the standing orders. I think they probably, and somebody correct me if I'm wrong, but they probably started becoming super popular, at least on my level, maybe like 9, 10 months ago is when a huge slew of them came out, especially from the Superior Court judges across our state. Rebecca, who's moderating the second panel, sent me an interesting standing order that I hadn't seen before. So most of the standing orders from trial court judges that I have seen have been disclosure AI use, right? If it's just like a little italicized something at the bottom of your brief or your filing, AI was used so that they are aware of it. Rebecca sent me one that was standing AI order that just said, you're a grown human. You're going to be held responsible as a grown human, whether you use AI or not, act accordingly. And I thought that was refreshing and very much in line to, I think, kind of the feeling that you two are giving me regarding AI and your use as an attorney. And both of you, I'd love to hear your opinions. Justice Benson, do you see value in uniform guidance from the judiciary regarding the use of AI?
Yeah. So first of all, I should say neither the court nor the committee that I chaired has sort of an official stance on standing orders other than I think sort of the more general guidance that AI is not sort of special when it comes to calling it out or using it or sanctioning it or anything like that. It's a tool like any other tool. From my perspective, I think I don't know the extent to which any standing order for AI is necessary. If a court is interested in one, the latter kind that you mentioned, I think is much less harmful and has maybe some limited benefit, right? Because again, I think that the question is more, it's more about education, right? I think I would hope that most litigants and most lawyers, I think at this point know there's a risk of AI sort of hallucinating cases and saying things that aren't true, and you have to be sort of using it in a way that's sort of careful and responsible. Pro se litigants may or may not know that, right? They may use AI for lots of other things and find it helpful, and so they use it in court, and they don't realize that it's actually pretty bad at doing some things on the legal side of things. So to that extent, to the extent that a pro se litigant is going to pay attention to standing orders, then that may be helpful. I really am not a fan of standing orders that require disclosure of AI use, just like I wouldn't be a fan of standing orders that require you to disclose which kind of word processor you use, right? Like it's a tool. And by requiring that disclosure in a way that suggests that it may be negative is going to disincentivize the use of these sorts of tools, which frankly, I think across the legal industry, they just, whether they're sort of required by clients, whether they're strongly encouraged by firms, or whether you're just whether you're a sort of a solo practitioner, a small firm, and you've got to use this in responsible ways to do your job effectively and cost efficiently for your clients. I just don't think it's helpful to suggest to lawyers that you shouldn't use it. And, I think if lawyers feel like, well, if I have to do this disclosure, it means that this judge might not look kindly upon my brief. I might not use AI. And you're doing a disservice to your clients because you're having to spend many more hours doing certain tasks than you otherwise would. So not a big fan of that. I think it was sort of a knee-jerk reaction in the early days of AI use to, oh gosh, people are making up cases, we better check. I mean, I think the better view is, I don't care what you use to file what you file before me. Just make sure that it complies with the rules and that you're not making up stuff. And then frankly, judges and trial courts have an independent obligation. If you think about, proposed orders, becoming orders, and those sorts of things, you have an independent obligation to make sure that the stuff that you file as an order or a judgment doesn't do those same things, right? And I don't think so. I don't know what sort of the goal of those kinds of disclosure requirements are, but I'm not sure what good they do.
Yeah, one of the things that I appreciate about being invited to speak on panels like this is always gaining a perspective that I had not had before, and I had never thought about it from that perspective. I will say this: I take no position on the necessity or propriety of standing orders, but if they're going to exist, I just ask that they be consistent. And that's consistent within a class of court and consistent across classes of courts. And I think the issue that we deal with in Georgia is that each class of court is its own separate entity and cannot be bound by another class of court. So what happens in the Council of Superior Court judges has no binding effect on what may happen among the Council of State Court judges and so forth. So I think with a technology like this that has as many potential tentacles, so to speak, as this one does, and is being as widely implemented and used as quickly as this one is, there needs to be consistency. Otherwise, you're not going to know what your requirements are from one courtroom to the next, one courthouse to the next, or one class of court to the next. And so if they are going to exist, and I take no position on that, there just needs to be consistency about them.
The one thing I'll add to that, I agree. It's herding cats is maybe not quite the right thing, but it is. We have so many judges and so many classes of courts with different dockets and different responsibilities and different kinds of things that they're most concerned about, and trying to sort of like top-down policy for that is pretty rare. And if it comes from anywhere, I guess it's judicial council, and I'm not sure how binding much of that is, depending on what it is. We do have maybe the sort of best thing that came out of the ad hoc committee is a permanent subcommittee on AI as part of the Judicial Council's Technology Committee, which has been established and has started meeting, to the extent that sort of at least guidance about standing orders can sort of come out and from sort of a top-down perspective. That I think would be the best hope for that, is that that's one of the things that they tackle, and that they look at sort of what do we think are at least the best practices for judges who are going to do that.
Well, I'd love to talk a little bit more about the toolkit. I'm a solo practitioner, rather recent, and when I started thinking about the use of AI, that's the first place I went. I mean, I was using free version of ChatGPT on my web browser, right? That's where I had started. If you guys were to give guidance to an attorney who said, I want to start working on AI tomorrow, here's your toolkit, y'all spent a lot of money, a lot of time on this. It's beautiful. How do I actually get started? And what is the most important part of the resources or the information that came out of the toolkit to get them started?
Yes, I think as with anything else, you need to build your perimeter first, which means you need to secure what you're doing. So my personal opinion is understanding what the terms mean. So the glossary of terms within the toolkit is helpful, but then understanding what risk considerations there are, both primarily as it relates to potential violations of the rules of professional conduct, which the toolkit, I think, does a very good job of explaining. Once you know what these terms mean and what the risks are, then you can really start assessing which platform to use or how to use it or how to implement it. But I don't think that you can responsibly use it until you know what the terms mean and what the risks are. Because the third step should be once you know those things, you should then be, as best you can, understanding what the terms of service of any particular platform are, so that you know if it creates that risk for you or doesn't create that risk for you. And that's a tedious task that is not only tedious, but is beyond the technical capability of a lot of lawyers, present company included. And so I think that's why the next step in the toolkit, or the next version of the toolkit, where there's sort of an overall assessment of these platforms and what they do and don't do, and the risk that they potentially create and don't create, will be very, very helpful to Georgia lawyers. I mean, when I've had the good fortune to speak to a lot of different groups about this topic over the last 18 months. And one that I currently get is, okay, I'm convinced I now need to use it, but where in the world do I begin? And I think that's where the toolkit's been very helpful. But the next question is, how do I know what are the different platforms? What is available to me, and which ones are the best for me in my practice? And there's no one size fits all answer to that. That's going to very much depend upon what you do and how you want to use it, more than anything. As an aside, you didn't ask this, but this is a good place for me to say this. My biggest fear as it relates to AI is that it's going to further the divide between big firms and medium and small firms. Big firms can afford to implement platforms that are sandboxed and are developed particular to their practice and their firm. There are only so many of those, and because the big firms can afford to pay to have them implemented, they are priced such that only big firms can afford them. And if AI use within a law firm is going to become necessary to remain competitive as a lawyer in a law firm, then it creates a real risk of further diminishing this mid-sized, small firm or solo practitioner.
So a couple things on that. On the last point that Daryl made, I get the concern. I think it's a real concern. I tend to be more of an optimist in that regard, in part because I think you may be right with respect to the landscape now. There's sort of proprietary tools and expensive tools that large firms can use and other firms don't. I think it may well be democratized sooner rather than later in terms of stuff that will be available to everyone. And ideal, like I think at some point this technology will be commoditized and part of sort of every tool that even small firms can use, right? If you think about Westlaw and Lexis, I suspect, for instance, like they may be behind now if you compare them to others, but I think they're quickly iterating and getting better. This is not an endorsement of any product, just sort of looking at sort of tools that we've kind of kicked the tires on in terms of just like what can they do and what are people using them for. And then the same with the kind of other tools that are out there, whether it's Microsoft Copilot, which is built into Microsoft Word that everybody uses. Again, I think they're iterating on that and starting to build in better models. And eventually, I think the models will sort of be better about the hallucinations and the things that maybe the expensive stuff they've really sort of worked on. So I think it will. I hope that it will become a thing where it will not sort of create a bigger divide, but will actually sort of help smaller firms and firms that don't have the huge resources of a large firm to actually do like really sophisticated work, because you can sort of magnify the work that you're able to do, and you can spend your time doing the stuff that needs your brain and sort of help sort of with the other stuff have AI kind of take charge of some of that. So I'm hopeful about that.
I hope you're right.
The other thing I'll say about like where people get started and what the tools are, I do want to flag. I mean, I think we've talked a lot today about kind of the risks and problems with AI with respect to the core legal work that we do. And those are there and they're real, and we need to be careful about them. But there are aspects of that work that it can already, I think, be helpful with. And there's all kinds of other work, right? The lower hanging fruit, administrative work, and things that aren't sort of the core stuff that's not going to generate text that's going to end up in your briefs, that I think can really help people now with even, again, the sort of models that are out there. And that maybe is the low hanging fruit for somebody who's a solo or in a small firm and wants to think about how can I be more efficient and maybe not need to spend as much time on some of these non-law things. I think that may be lower hanging.
Yeah, and that's interesting. When you guys were talking too about competency and the rule around that, it sparked my thought process a little bit, Mr. Sutton, when you were talking about how this will eventually just be the way that law is practiced, right? Whether it is substantive legal text, as Justice Pinson just said, or automated intake forms sent when a client reaches out, right? If I'm in court, I'm a solo practitioner, I have a virtual assistant who isn't going to get there. That kind of AI technology and such can be very helpful. At what point does competency in AI be a BA requirement for an attorney?
I don't know that. I don't no time in the near future. I'll put it that way. I think that the technology is becoming and will become more ubiquitous, and its use will be more ubiquitous. But I think that those who are promising that this will change the world are those who benefit financially from it changing the world. I don't know that. So I don't know that at least in our generation, and perhaps not even my children's generation, will it actually fundamentally change the way we live or operate. I've said this often over the past 18 months. The reason I don't fear it and don't believe it would replace me is because, at least for what we do, especially litigators, there is a uniquely human element to litigating and lawyering in particular. I believe the use of independent judgment, the expression of empathy or sympathy or humor or all human emotions. No AI program will ever be able to do that. And anybody who's tried a case before a jury knows you got to have all those in spades to effectively try a case. You can't put a robot in a courtroom and expect it to try a case before a jury the way a human can. And I don't know that it ever will be able to, but it certainly isn't in the near future, I don't believe. But I don't know that you'll. Do you need a? This is a really bad example, but I'll use it anyway. Do you need to be competent in the use of email to be a competent lawyer, or competent in how Microsoft Word works to be a competent lawyer? I mean, they're all just technology platforms that you use to enhance or make your practice easier. So I don't know that you'll ever need to be completely competent in the use of AI. Now, AI obviously has. I don't mean to minimize or compare the two, because I understand that the artificial intelligence technology has such greater capability than any of those rudimentary other forms of technology. But I think the point is still the same.
I'll make a version of maybe an opposing argument. I think AI I think we can think about sort of two aspects of AI and how it can sort of come into sort of the practice of law and the administration of a legal practice. One is time, right? So I think right now there are certain things that it can do light years faster than we can do. And of course you have to review and those sorts of things, but it can sort of reduce the amount of time that someone needs to work on a particular matter to get it to sort of a good level of representation. The other piece of it is sort of quality of work. In the legal profession, I think it's much farther away from sort of raising that ceiling. I think it raises the floor. Today, right now, I think use of AI can raise the floor for not great lawyers to write better briefs, et cetera, sort of hallucinations and things aside. But the human element that Daryl talks about, sort of the good lawyer, the good brief writer, AI is not anywhere close to sort of reaching that ceiling right now. There may come a time down the road, I can't predict the future, where both of those things come together in a way that if you're not using it, you are just a much worse lawyer than somebody who is using it. Where the sort of competency line is, I don't know, but I could see in the future that the technology improving to an extent to where if you're not using the technology, you're charging your clients an order of magnitude more money to do the same job worse, right? And so that's where I could see it coming into play.
Yeah, I think we need to be careful not to confuse. It's a great point. We need to be careful not to confuse quality with competency. Because you can be competent and not produce quality work product. So I think as a competency is what, at least how I look at it, is a base level of ability. And whereas you can be exponentially greater than that base level and be a quality lawyer.
Sure. A particular interest of mine, as what I do is serve vulnerable populations, and I'm very interested in underserved communities. I see the benefits of AI expanding the access to justice and the access to attorneys and legal resources, especially in those more rural parts of our state, to be huge, right? The potential is ginormous. What is both, and excuse me if your committees have not necessarily identified this as an issue, but I know access to justice is a nice buzzword, is a nice buzz phrase, and people use it. But how does that come into play when we think about AI? And I would love to hear from both perspectives.
So I tend to agree with you on a theoretical level that the power of it and the breadth of it and the scope of it theoretically provides greater opportunity for those who don't have ready access to legal resources to have access to them. I think from a practical perspective, at least right now, depending upon how you're using it, it's still not sophisticated enough to stand in the place of a human legal resource. And I don't know that it gets you in underserved communities, there are more comprehensive issues creating barriers to access to justice that AI isn't going to solve. And until you solve those underlying, more pervasive, comprehensive issues, AI can provide some additional information and knowledge and education, but it's not going to, it can't break down the barriers that actually create the lack of access to justice to begin with.
So I generally agree with that. It's not a panacea. Again, I have some optimism about it, particularly as it gets better at, again, sort of doing legal work more efficiently and with higher quality. I mean, think about, persistently understaffed public service organizations like Legal Aid and Georgia Legal Services. If they can sort of magnify the work that those organizations are able to do through some combination of those lawyers themselves using sort of products responsibly, and maybe creating tools for those underserved communities to be able to use those things in certain circumstances. I think there's a ton of promise out there. Again, the devil is in the details of like what tools can we create that we can trust? What tools can they use that they can actually do that work and not sort of introduce the risks and the problems of AI? But I think, that our ad hoc committee, I think Daryl was sort of the co-chair of like the Access to Justice subcommittee on that committee, which, that's a big component of what they looked at. It's like, is there something there for us to look at further with respect to serving underserved communities and legal deserts and all those sorts of things? And obviously, we're in the early stages.